On to this. Day 3 of the preliminary hearing in the murder and sexual assault case against singer David in downtown LA. To provide the very latest, we have civil and criminal defense attorney Brian Watkins hopping on the Fox Local app, the Zoom with me today. Brian, thank you so much for being with me.
Thanks for having me.
What has caught your attention so far we're now into the third day of the hearing? They've talked about blood that was found at the scene and also in the Tesla. They've gone over some cell phone records. There have been law enforcement officers who have taken the stand. They've talked about David's finances. His financial manager was also on the stand. What's caught your attention?
Well, the testimony about his finances is pretty unique because what the prosecution's trying to do there is saying that when you have murder for financial gain, that also becomes a capital death penalty type case. I know that they can do the death penalty now, but it shores it up more, and it really supports a capital case when you have murder for financial gain. And their argument is that lack of losing money is in turn financial gain. So he killed her in order not to lose his music career, because she allegedly said that I'm going to, turn you in and basically ruin your career because of these alleged affairs that he was having.
Right. And the prosecution making that point with the witnesses, the defense pushing back, saying David had nothing to do with his finances. He didn't know anything because his mother handled his finances. What do you think of that?
I think that's a shot in the dark. I mean, everybody knows about their finances. Yes, his mother may be, his accountant, but to say that I know when I'm losing money and I know if my career is over, I'm not going to have any money, I don't think you need your accountant to tell you that.
What evidence, I've named some of it, but what evidence does the prosecutor have to support this case?
I mean, you have a chopped up body in your car. You don't need much more than that. That forces him to take the stand in a case like this to explain why it is you have a chopped up teenage girl in the trunk of your car. And so it's a very strong case for the prosecution, let alone the fact that he ordered a body bag, ordered, other items that are used to chop up a body. He has a chainsaw in his house. He's not a gardener. He's got a lot of explaining to do. And although you do have a constitutional right not to testify, there's no way you're going to go through a trial and not explain that stuff.
Okay, so you are betting on, if in fact the judge says that this will go to trial, that David will take the stand.
He has to. He has to explain that. You have to explain why there's a chopped up teenager who used to be your ex-girlfriend in your car. And if you do not do that, you are going down. You will be found guilty in probably less than an hour of deliberation.
I was talking to another defense attorney about this on the stream earlier this week. He brought up the case of Robert Durst, in that he, in one courtroom, was acquitted based on the defense of self-defense. There was also in that case dismemberment of the body after the fact. The point being, this defense attorney said that this case could be sort of the cousin of the Robert Durst acquittal, in that the cause of death is what equates to murder. The dismemberment happens after the fact. So if the defense could prove, for instance, that this is self-defense, that could surprise a lot of people. What do you think?
Self-defense against a teenage girl. Okay. When there's evidence that she was stabbed also. So I think we're going to have a cause of death of stabbing and then a later dismemberment of the body. So I think it's a very different case than that case for,
Yeah, no, I mean, you make a great point. I just wanted to get your thoughts on that. This is day 3, as mentioned. They were expecting 3 to 5 days of this preliminary hearing. Can you talk more about this issue of the burden of proof isn't as high in a preliminary hearing versus in the actual trial itself?
Right. In a preliminary hearing, all the judge has to find is preponderance of the evidence, which means, is there enough evidence here to suggest that he did it? Not that he's guilty beyond any reasonable doubt, but are we wasting everyone's time? Should this individual be set free because the prosecution has no evidence that he did it? That's the very, very low standard that the prosecution have. He absolutely will be bound over for trial. I guarantee you that 100%, because the evidence, the burden there is very low. And just the fact that there's a dead body in your car would be enough to bind him over.
Is there enough? I was just you just answered my question. So without a doubt, you're saying that this will go to trial.
Absolutely, without a doubt.
Okay. Have you been? We have a reporter in the courtroom, and she's been taking incredible notes. She's providing our daily reports each evening, and she has noticed the demeanor of David in the courtroom. His defense asked that he not have handcuffs on, and the judge granted that request, so he doesn't have handcuffs on, but he is there a chain. Handcuffed, if you will, chain linked to his chair there, so he cannot make a run for it, if you will. She has described his demeanor as stoic, nonchalant, non-emotional in the courtroom. What do you make of that? And mind you, on day one, there were some pretty gruesome images that were shown.
It's a good thing that there's not a jury present looking at that, because that would weigh very heavily in the jury's eyes if he had that demeanor while he was listening to and seeing those photos of that evidence that the prosecution is putting on. Here, it's a preliminary hearing, which means you only have the judge making the call. There is no jury present. And the judge is also looking at his demeanor. He's going to bind him over on the evidence, but you have to understand that this judge is also understanding and taking in his demeanor to say, whether or not he thinks that he did it, because judges are human beings too. And once you start rooting for one side or another, it could be bad. Judges, yes, they're supposed to remain neutral, but again, they're human beings.
If you were defending David, what would your take be?
Well, at this stage, I think the defense is doing a great job. And how are they doing a great job? Because they're not putting on any evidence. They're not doing anything. They're not showing their cards in any way, shape, or form. They know that this is going to trial. I think they're going to be saving their good cards for the trial. There's no need to reveal them now, which I think is a good strategy for the defense.
Yeah, in terms of, collecting the DNA evidence, what I've seen from our note taking inside the courtroom is prosecution has criminologists on the stand from LAPD, those who collected the evidence, and the defense's the line of questioning has been, were you wearing PPE when you collected this evidence? Why didn't you take the chainsaws into custody, or as evidence, which in fact that was one of the questions that was asked. So they're just trying to punch holes in how the evidence was handled.
Well, it's got a little bit problematic, because asking the prosecution, why don't you have more evidence? I don't know how well that goes over. You got to understand, DNA is only good for one thing, to tell you whose blood it is. The fact that there's no DNA on a chainsaw doesn't mean you didn't touch the chainsaw. It doesn't prove that one way or the other. So a lot of these questions, and of course, there's going to be his DNA everywhere and items in his house that he lives in. So that's not, this is not a redoing of the OJ case by any means, and the fact that there's no DNA on the chainsaw, the fact that they didn't test the DNA, the chainsaw for DNA, is kind of irrelevant. Like I said, if there was no DNA on it, it doesn't prove that he didn't touch it. And if he did have his DNA on it, what does that prove? He owns the chainsaw. So it's neither here nor there. Like I said, they're not really revealing their cards, but the question of the prosecution is, how come you don't have more evidence? For a preliminary hearing, that's okay, but that will not go well with a jury trial.
Anything else you'd like to add? Any points you'd like to make?
I think that the prosecution has a very, very strong case, and I know that what the prosecution is presenting is going to force him to have to take the stand. Although he has a constitutional right not to, it would be foolish for him not to explain how his girlfriend's chopped up body was found in his car.
Let me actually, I was thinking of some other questions I wanted to ask you, just because there's so many angles to this since this started on Monday. Today, it was noted from our Christina Gonzalez that his parents, his family is not there in the courtroom. I believe she said his parents weren't there, which she said if you were going to testify in the trial, you cannot be in the preliminary hearing. Is that true?
No, that's not true. You could be called as a witness at preliminary hearing and then subsequently testify at the trial. As to why his parents aren't there, I don't know. I mean, one thing that I do want to point out to about the prosecution and the defense is that the defense may have a good case regarding the sexual, the sexual abuse of a minor. I don't know how they're going to prove actual sexual intercourse or any sort of intimacy between them. Even being girlfriend and boyfriend doesn't actually prove that. So that would be one issue. I think the defense is going to have a good leg to stand on. But the murder, the evidence so far is very strong.
Yeah, that's an interesting point. Also, I thought it was interesting. Each day there's so much interest in this case because of the celebrity of it all, of course. That each day, 10 public seats are available. You have to line up early, as you know. And the majority of these 10 people who are allowed into the courtroom tend to be those social media influencers, bloggers. They're reporting on this online. And one of those influencers, podcasters, was reprimanded and removed from the courtroom this morning because the judge said that she was live reporting from the courtroom, which is not allowed. You can disseminate your information on a break. You cannot do it live. So when our reporter sends us notes in the newsroom, it is only on a break. It's not at the time. It's not live. So that podcaster was removed. Another person from the public was also removed because he was trying to get in touch with Celeste Rivas's family and talk to the family itself. They are in the courtroom. So I thought that was interesting. That's how today's hearing opened up. What do you make of the judge and the actions that she took?
Well, it's good. She wants to preserve. I don't want it, she doesn't want anybody coming back saying we got to move the venue now because the jury pool is somewhat corrupted because of either this live feed or some commentary or something that could poison the jury pool. So she wants to keep it as clean as possible because she doesn't want this coming back on any appeal or somebody wanting a mistrial based on some misconduct or the way she conducted the courtroom. So she's going to be better safe than sorry. She's going to remove anybody who she even suspects of doing anything that could poison this jury pool.
Yeah. Okay. Well, it was a podcaster, and then my memory just came back to me, and it was a private investigator that appears on news outlets quite a bit for his private investigating, and he was asked to leave the courtroom today because he was trying to reach out to Celeste Rivas Hernandez's family. David, by the way, I should note, is pleading not guilty. The 21-year-old is pleading not guilty. All right, Brian Watkins, civil and criminal defense attorney, thank you.
Thanks for having me.
We'll have you back.